Okay. Good morning and welcome to today's meeting of the Law and Policy Committee of the California Fair Political Practices Commission. Today is Thursday, July 16th, 2026. Ms. Vo, will you please take roll?
Commissioner Brandt?
Here.
Chair Silver?
Here. One moment to pull up our agenda. Okay, let's start with item number 1. That's going to be public comment for items not on today's agenda. Do we have any public comment for items not on today's agenda? Hearing and seeing none. Let's move on to item number 2. That's going to be approval of our committee minutes from the January 2026 meeting. Any comments, questions from commissioners? No? Any public comment on our January minutes? Hearing and seeing none, I'm going to move to approve the minutes. Do I have a second? Commissioner Brandt?
Oh, yes, second, sorry.
No
I
problem.
guess it's just us, yeah, right.
Lots of pressure.
Okay, yeah.
Ms. Vo?
Commissioner Brandt?
Aye.
Chair Silver?
Aye.
Motion passes.
Okay, here we go. Item number 3. So item number 3 is going to be a discussion of proposed regulation 18450.12 and amendments to regulation 18401 titled AI use in campaign advertisement disclosure and related record keeping. And we have presenting to us today our general counsel, Dave Bainbridge. Good morning, Mr. Bainbridge.
Good morning. Dave Bainbridge, General Counsel. I am here filling in for Zach Norton, who's the attorney that has been working on this project and is the real expert in terms of our legal division people here. But he's off hiking in Yosemite somewhere, so I'll do my best to fill in. I'm just going to provide a little context for what we're looking at and then get out of the way and let the commissioners discuss and our guests provide their perspectives. They know more about this than me when it comes to AI. So I'll just tee it up and then we can let them speak. What the start of this was, the Enforcement Division came to us and was looking for to get the commission's opinion on how to interpret this new statute, section 84514, requiring disclaimers on advertisements that utilize AI for campaign advertisements. So we started the process of drafting a regulation that we thought might be helpful to them to help get commission perspective on what this statute exactly means. So that's 18450.12. This was presented to the commission back in June. And so the commission has had a chance to weigh in. We've made quite a few changes since then, which I'll go over quickly. Just to summarize the law, so we're all kind of talking about the same thing. The statute is a little, the way I read statutes is a little wonky and difficult to read. But I think to really focus on what we're looking at here is when is a disclaimer required on an ad that utilizes artificial intelligence. It's not any ad that has artificial intelligence. There are some restrictors on it. So what it provides, I've got the statute up here. The relevant part is right here in D1.2. And an ad utilizing AI campaign ad is going to require that it have a disclaimer if it's any image, audio, video, or other media that is generated or substantially altered using artificial intelligence. And then it goes on to describe what generated means, which is the visual or audio media is entirely created using artificial intelligence and would falsely appear to a reasonable person to be authentic. Oh, we're zooming in, that was fancy. The second prong of that, so that is entirely created using AI, that's the standard. The second standard is when it is substantially altered. And in that case, it's when the visual or audio media is materially altered by artificial intelligence, such that the alterations would cause a reasonable person to have a fundamentally different understanding of the altered media when compared to an unaltered version. That particular phrase is the one where enforcement said we could really use some guidance, particularly from the commission, on what that means. So our first draft, the regulation that we presented in June, was specifically attempting to define that section, the materially altered. And you'll see in subdivision B here, this was our first draft defining materially altered. So what we came up with, and this was largely based, Zach had done quite a bit of research on what other states had done, other ways that people have attempted to define artificial intelligence in this context. And the draft that we came up with was someone would have a fundamentally different understanding of the altered media when it depicts an individual saying or doing something the individual did not say or do, or contains a realistic depiction of something that did not occur. Based on our reading of the statute and all of the legislative history on this topic, this was our best guess at what the legislature was really trying to get at when they were talking about a fundamentally different understanding. So that's the second prong. At the commission meeting in June, we had a discussion about this. Chair Silver suggested that maybe we should also have a definition for the first prong, which is, what does authentic mean? If something falsely appears to be authentic, well, what does authentic mean? So on the agenda this month, we have drafted a potential definition of authentic. It's largely based on dictionary versions of what the word authentic means. But you see it here, it's subdivision B. And what we had come up with to this point is authentic, so let's see. Media entirely created using artificial intelligence would falsely appear to a reasonable person to be authentic when the artificial intelligence is used to create any visual or audio media that appears to be genuine and realistic depictions of person, place, or thing. So what we're trying to get at is, does the ad look real? That was what we thought authentic was trying to convey. Do people think it's really what it is as opposed to something created by artificial intelligence? So that's what we have here. Obviously, we are open to suggestion, particularly from the experts that we have in the room today on how better to approach this. To us, this seemed consistent with what we believe the legislative intent was and what the language of the statute is. Just a few other items that we plan to address. So this draft is on the agenda as well. Since then, we've had some internal discussions and come away with a few other suggestions for changes. And I'll just list those real quick for the purpose of possible discussion on them. Additional plan changes, let me pull up the statute. I think it'll be easier to talk about it in that context. Oh no, I'm sorry, let me do this. It's been suggested that we delete subdivision A. It was intended to address that situation where people are using common software that helps with grammar, spelling, but it's really an unnecessary provision because the statute itself is focused on media. So we intend to delete that subdivision A as we think it's unnecessary in the next draft, which we'll bring up probably at the time of adoption. The second change we're considering is to define what the term entirely created means. So if you'll remember, entirely created is found here, which is in the for when something is generated by AI, and that's the authenticity, the authentic standard. There's been quite a few questions about what does entirely created mean. We're proposing a definition that would say entirely created means created using a word prompt and not existing images or audio. Again, certainly open to suggestions. This is what we've come up with to this point, but we do believe that having some definition of entirely created could also be helpful to applying the statute. You had seen in this, jumping around to the drafts, the new draft on the agenda right now states specifically that cartoons and animated visual media are not authentic. I guess there were quite a few ads that were cartoonish or animated in this last go around, and it was suggested that this be a provision. What we are now considering doing is creating its own section and making it an exclusion for both entirely created and the substantially altered wings of this analysis, because we don't believe that cartoons would meet either of these provisions where you would require a disclosure for AI. The last suggestion that we're working on is maybe improving the language in subdivision C here. It's been suggested that it may be difficult from an investigation standpoint to determine whether someone had done or said something at any point in time and to prove that they had not in order to analyze this section. So that's an area we're looking into how to improve. At this point, I have no suggestions, so hopefully if this is something that needs to be improved, there's ideas in the room or we come up with something between now and adoption in August. I would just say in closing, this is a difficult area to legislate, to regulate in. just because it's rapidly evolving. So I think everyone in the room here and probably most people involved understand that this is difficult and may require some tweaking as we go through time, but we'd like to, at this point, at least have something to help with interpreting the current statute.
Excellent. Well, thank you for that summary. That's really helpful, and thank you for stepping in for Commission Counsel Norton. I think one aspect of this would be helpful for us to run through before we start talking to the guests, witnesses, what have you, is the legislative history here. I thought Commission Counsel Norton did a great job in the pre-notice memo, kind of laying out the context of AB 2355, the bill that provides for Government Code Section 84514 that we're talking about today in regards to its relationship to two other bills that were introduced and subsequently signed by the governor, and then, as I understand, struck down by the courts for constitutionality issues. But those dealt with deepfakes. Would you mind expanding on that? And then I kind of want to explore the evolution of the bill, and I can touch on that afterwards. So I want to start by talking about the bill package that dealt with deepfakes.
Sure, this was part of a package of three related legislation. I think they all had different authors, but they all kind of went through the process together and were seen as a package to address the use of AI in campaigns. The first two bills were prohibitions on the use of AI in certain circumstances, which is largely why they were challenged and struck down. One of them was struck down under First Amendment free speech grounds. This federal court judge determined that it was an unlawful restriction on free speech. The second one, which was a very similar bill that required social media companies to take down particular ads utilizing AI that had they were using campaigns or in political situations. That one was struck down on grounds that it violated a federal statute. However, the court seemed to indicate in their opinion that they probably would have found it also a violation of the First Amendment if they needed to get there. The third bill is this one, the law that we're talking about today. The major difference between it and those other two, why I don't believe it's been challenged yet and hasn't been overturned, is that it is a disclosure requirement on the advertisement as opposed to a prohibition. Disclosure requirements are considered compelled speech, so they are subject to First Amendment analysis. It's just the level of scrutiny is not as high for disclosures as it is for prohibitions themselves. So at this point, this law has not been challenged. I think it's also a little narrower than the other two in terms of what activity is where they're compelling the speech in the form of the disclaimer. So as far as I know, no challenges have been filed to this yet. I would probably be one of the first to know if they had. And those are my brief analysis of why this is different than the first two bills, which have been struck down. I think what the chair's getting at is they were considered as sort of a package deal to try to address the use of AI that was maybe deceptive or unclear to the public that campaigns were using AI as opposed to what they describe as genuine ads.
And I think that was the crux of our discussion, Commissioner Brandt, during the May Commission meeting, or I shouldn't say the crux, one aspect of our discussion. So I took a look back at the legislative history because I absolutely agree with you. I think we have to, it's not up to us to decide what the best policy is. It's up to the legislature. We need to enforce these laws consistent with their intent. So I went and I took a look at the language that was initially introduced by the author. And it was actually quite explicitly broader than what we're looking at today. So as I understand it, it was going to apply to political advertisements that were generated in whole or in part using artificial intelligence. So there wasn't that qualification that we saw in subsequent amendments where you had falsely appeared to be authentic or a substantial material alteration. So bill is introduced with this broad language. Then it goes to Assembly Elections Committee. An Assembly Elections Committee, they highlight some of the issues with a broad ban, including that it could result in disclaimers that the public could disregard or attach no significance to. It also mentioned in the alternative it could unintentionally impact the public's view of what the communication actually means to convey, right? So we saw that. There were also concerns about how some aspects of technology could trigger AI where it would not be the intent of the author. For instance, I think the example they used was like the focus on a lens of a phone. Like if there's autofocus and AI is making a calculation as to how to portray a specific image, or is that going to trigger a disclaimer? So basically, the committee came to the conclusion this is going to be a very broad disclaimer requirement. Is that really what we want here? And then subsequent to that, there were amendments made to the bill to add what we see today, which is the two-prong analysis. The falsely appears to be authentic, and then the substantially altered, right? And then we see in the Judiciary Committee, interprets these changes as essentially doing the following, right? It says under both categories, so under the false appearance of authenticity and the substantially altered, under both categories, the disclosure requirement would only apply if the use of AI results in deceptive material. So to me, I'm putting this all together, and what I see here is the legislature didn't feel that the use of AI by its nature is deceptive or harmful or undermines the political process. It's concerned about deception, and that's really consistent with the 3-bill package that we just talked about. The tricky part is, obviously the language, right? It appears that the legislature decided to have 2 tests here, one for material that was entirely created, quote unquote, with AI, and one for materially altered. So naturally, you would think you would have 2 distinct standards. But the way that I see it is essentially you have to have 2 different approaches because you're looking at 2 different modes of developing political communication, right? One, you're going to have a original piece of content to alter, and the other you're not. So you can't use the same standard in the second one that you would for the first one because it wouldn't be possible. You wouldn't be able to say that the original, you're supposed to compare the original to the original. There just isn't that level of evidence or information to conduct that analysis. So that's where I'm at in terms of legislative intent. I am interested to hear if there's any other feedback from our witnesses or folks that are testifying as to those specific items. But my goal with this obviously is to follow the legislative intent of the legislature. That's how I see it personally, as one commissioner. And I want to make sure that we ultimately have a regulation here that provides the public with the level of disclosure that they expect and level of disclosure that they understand. I want to make sure it's meaningful disclosure so that we're actually not potentially undermining political communication, the political process. Any comments, Commissioner, before we go to witnesses?
Let's go to witness and then I have
Excellent.
comments.
Okay. It appears we have public comment. Do we want to start with Ms. Lair, because you're closest to the table?
Can we have them all up? I mean, what's public, so there's public comment? So tell me about that. I mean, so in other words, we've invited people up here because we want to hear their perspectives. Can we have them all up, or what's?
Sure.
Are they? I want to be able to have some engagement with them, not just have them present statements.
Yep, we can do this however we want to. If you want, I'll move over and sit over there. We can put a couple microphones at this table. Someone can be at that microphone. As long as they're speaking into microphones, we can make this a conversation as opposed to testimony if that's
If that's okay,
preferred.
Mr. Chairman?
course, yeah.
Okay, thank you. Okay, come on up. Can we put up the statute?
Yeah, I'm gonna grab another chair.
We're gonna, yep, come on up, all the way to the front. I think we need one more chair.
And then we also have somebody on the phone line, so I think we just want to make sure that
We do.
they're available.
Who's on the phone? Who's on the phone?
Ken from Cited.
Okay. So, you ready for me to?
Sure.
Okay. Ms. Vogt, could you put up the language from the statute, those two provisions, just so we can, because I want to frame this. So let me explain why I really insisted that we needed you here. So you know my background, my outside world. I work at the National Judicial College, Director of Justice Solutions and Innovation. I lead our AI program. I'm not the AI guy, but I lead our program for responding to judges' needs on AI. And so we are doing this year, and it's been changing so quickly this last 6 months even. So we are doing programs for judges on a number of ways, sometimes in our courses. We've done a webinar on the fundamentals of court, and we're focused on judges using. We're not focused on how attorneys as much are using it and those kinds of things, and all the, the deep fakes and all those things from attorneys. But we're focused on judges' use. And then they're encountering it more. What we're hearing is from judges, we're encountering it more and more. And then we did a track at a National Judicial Summit recently. And the evidence discussion, it was an all-day track. The evidence part of it talked about the range of things and how much do you know, and what is, we use the word authenticity, where is the word we use? Yes. And so the range of what's authentic and that kind of thing. And is it, if the AI adjusts the lighting, that kind of thing. So what I'm hoping to hear from you is understand how you think about this, and how you, can we put up the language? Yeah. How you think, how you approach these things, what, to the extent you can, your intent and how you're using it. Let me go specifically to the language. Onto generated or substantially altered using artificial intelligence. If either of the following met, visual or audio media is entirely created with artificial intelligence. So questions I have there are entirely created. What does that mean? And falsely appear to be reasonable to a reasonable person to be authentic. What is a reasonable person in this case? So, and I'll give you a concrete example of, so we created a website for a program I have, and my staff used AI created, it was about judges and conversations, and it used photos that were created completely by AI. And could somebody tell that they were created or fake? And part of this is, what is deception, and is it deception? And my wife, who teaches research, she's a librarian at UC Davis Law School, and she does AI. She's helping students learn about AI and what the dangers are and all those kinds of things. And her response when she first saw the website was, "This is totally created. You've got to give them notice that this is all created. I can tell those photos are." But is she a reasonable person? I mean, she's hypersensitive to this stuff and is very concerned about all this kind of stuff. So some of my questions are, what is a reasonable person in this case? Is this someone like that, or is this just the person on the street? that's goes, oh, that looks authentic. And then the next one is materially altered. What is material? And that's the question that I've been struggling with about what is it when it changes the appearance, but is that material? And I guess in some ways lawyers may have clear view on what that is, but I'd like to hear from your perspective of do you intend material? I mean, in other words, are there things, and is it obvious, would cause a reasonable person to have a fundamentally different understanding of the altered media when comparing it to an unaltered version? So I'm trying to understand how you think about what you're doing, and do you create things that are intentionally it should be obvious, like the video from the mayor's race in LA, from May. That was obvious to, I think to most people. But do you create things, and what's the purpose of AI, and how is those are the things I'm trying to understand from your perspective about what you're doing when you're using AI to understand what is a reasonable person, what is fundamentally different understanding, what is materially altered, and do you do things just to make it look nice? Make it look, clean up their they get rid of the lines on there, make them look a little younger. I don't know. So that's kind of where I'm going. That's where I wanted to start from. So I would welcome your just giving us some opening comments, and then we can go into, and I can ask you questions and that kind of stuff. So leave it to you on that but that's kind of where I'm started. I'm trying to understand, what do you do with this? Do you intend to do things? I mean, and I appreciated adding the animation exception. That's that's created, but what are you trying to do? So who wants to start? So
Well, I'm going to insert myself for 1 second. Just thank all of you for coming.
Oh
here
yeah.
today.
Oh, did I not do that? Yeah. Thank
No.
you. Yes. Okay.
No, you're
Thank
totally
you.
good.
Yes, because I really wanted to have you here. So I can't thank you enough for taking time to come and have this conversation to help us understand how it works. And and ultimately, I think he's right about deception and what is in this political dialogue. And we're going to have AI no matter what. I mean, it's happening, and that's why 6 months ago we had judges saying, "Oh, I'm just not going to use it. I'm just going to." It's like that's not possible. So how can we make the political conversation open and robust? So
I think those are all important questions, and I'm so glad all of you are here today to give us your feedback on those. I'm going to introduce each of you, unless you have any concerns with that. Okay, great. And then do we have anybody on the phone? Would you mind introducing yourself first? Okay, well, I'm sure he'll just chime in while I'm introducing you folks, and we'll go from there. So let's start from left to right. We have Ashley Titus, partner at Bell McAndrews Hilltech, with us here today. Good morning. We have Casey Jenkins, also a associate attorney with Bell McAndrews Hilltech. We have a political strategist, Matt Rexroad, with us this morning. We have Hillary Lair, a managing director at Higher Grounds Labs, a venture capital group focused on investing in companies using technology for political campaigns, joining us as well. So why don't we start by touching on those topics that Commissioner Brandt laid out for us? What do you think about we focus on the first prong? We start with a discussion related to the first prong, the reasonable person standard you mentioned, authenticity, perhaps the inclusion of the word falsely, and then we move on to the second prong.
I think it'd be helpful for them to open with what's the goal of AI? What if we want to accomplish this goal of having a robust conversation? AI is going to be part of it, but people understanding what the AI when AI is used. What's your view of what's the big picture? I think can we start
That
there?
works for me.
Big
Sure.
picture of how
why don't we start with you, Ms. Lair?
Thank you so much for having me today. I'm so delighted. Oh, Thank you. To be here. My name's Hillary Lear. I'm a managing director at Higher Ground Labs, but today I'll also be wearing just two other hats to bring into the conversation. One is I'm a committee member for the American Association of Political Consultants Bipartisan AI and Emerging Tech Committee. We've tried to provide guidance for political consultants nationally on deepfakes, meaningful disclosure of AI and campaign content, and a variety of other pieces. And I have a little bit of new research that I prepared to share today. And the other hat is I'm a policy fellow at the Harvard Kennedy School's Ash Center for Democratic Governance and Innovation. So trying to think both about the everyday logistics of how we implement new technology into campaigns, but also the bigger picture societal environment that those technologies are being deployed in. And I appreciate this committee's sensitivity too, that it's not just about the technology, but where the public is at on this fantastic new technology set that these ads are going into, and really how do we balance those effectively. So just to very quickly share a little bit of new research that the American Association of Political Consultants put together, we've really wanted to help provide a little bit more empirical evidence on how disclosures of AI-generated content in political ads is being received by the general public so that we can understand some of the downstream effects of disclosures as they're happening in real time. And I think, one of the big caveats here is that personally, I really expect this to change over time. We're really in some of the first electoral cycles where AI-generated content is being created and deployed, and the public's taste and tolerance for that content and how that reflects in the candidates' electoral results is still, I think, really being determined over the next couple of cycles. So a little bit of flexibility and observation from all of us as we adapt to the public's tolerance, I think, will be significant. In the short term, it does appear currently that there is some backlash to disclosure generally that I think is important to take into consideration so that as we implement disclosure policy, it can help build the public's understanding and acceptance of AI in appropriate ways without opening up additional pathways for distrust or some of the more negative effects that we're seeing in some of the initial research.
And I apologize for interrupting. I just wanted to clarify. So the backlash, is that from the folks who are required to provide the disclaimers, or that's an impact we're seeing on the public who are viewing the disclaimers?
Of the public receiving the disclaimers.
Okay.
So recently, and I can just share very quickly some of the results. So the American Association of Political Consultants commissioned a study, bipartisan constructed study, using a tool called Swayable to recruit about 7,800 participants that were exposed to 4 treatment groups, plain old school political content, AI generated content, labeled, not labeled, and then observe the results and sentiments in real time of the participants in this kind of RCT study. And what they found is at the moment that the AI disclaimer appeared in the ad, overall trust in the content itself and the ranking of the ad declined. And that was whether or not the content was AI generated or not AI generated. So it was actually the presence of the disclosure itself that led to a net distrust experience on behalf of the participants in a significant way. So one kind of shorthand way that we've been talking about it on the committee is that the disclosure presents a cognitive speed bump for people as they're evaluating what they're perceiving. Second, the size of the AI disclaimer also was significant. The larger ad had the net negative effects, and there was also less certainty that people saw the smaller disclosure note at all. I think the other thing that's important here when we think about whether or not viewers in the public are seeing the disclosure is that we also live in a world where 1 in 5 adults is getting all of their news on TikTok. And so to the extent that clipping, where you take a short piece of a recording of an ad or a piece of content and share it widely on social media, enters an environment where it won't always be clear whether or not the disclaimer is present when the content is clipped and reshared. It's kind of a separate thing related to the other bills. Third is that the viewers interpret the disclaimer in dramatically different ways. So we had the participants rank their tech comfort from low to high. High tech comfort viewers interpreted the disclaimer less negatively than low comfort members of the public who received the disclaimer. So the effects of disclaimer visibility for voters throughout the public will vary based on the level of tech comfort and sophistication that the individuals self-identify. So the effects of that treatment are not uniform amongst the public, which presents another challenge for us, which I'll come back to in a second. And finally, Oh, yeah, and the tech familiarity shapes the impact. So there was a little bit, there were kind of two effects here. One, is that the way that the ad is structured, currently what we're seeing in states across the country is it's structured a little bit more like the stand by your ad disclaimers or other FEC required disclosures. What the American Association of Political Consultants has been thinking about is a more meaningful disclosure framework. So not whether or not AI was used, but how. Was it a dramatization? Was it light photo editing, for vanity? Was it a complete fabrication of a hypothetical event or a fabrication of a specific event that impacts the perception of a candidate in a meaningful way to a voter? And if you have a little bit of a rubric that can evaluate the type of way the AI was used, either for fabrication or alteration, and then have that rubric transposed over the effect that it would have on a voter's opinion of a candidate, which is what this is all about, that can help provide a little bit of a prioritization schema for evaluating the effects of it for a reasonable person. And then finally, so I feel like I'm hogging a lot of time here. Okay, so the meaningful disclosure framework can be kind of just a helpful piece, evaluating not just whether or not AI was used, but how it was used. That might provide a helpful educational pathway to the public so that as they're seeing AI disclaimers, they're also learning and building the skill of evaluating the content and evaluating the range of potential treatments on that content so that we're developing a broader public literacy that closes the perception gap that can be harmful for the good actors who do comply with AI disclaimers without opening up, vulnerability to the liar's dividend, where bad actors who don't care about our laws keep creating the most harmful versions of content kind of scot-free while the good actors try to adhere to various frameworks. And so that's the main piece of the new research that came out. And I shared the results a little bit earlier. The report itself is going to be released in the next couple of days, but you have, hot off the press, preliminary results. So wanted to just be here today to support with a little bit of the initial empirical research that's being done, to introduce some of the thinking that this bipartisan committee at the AAPC has done on meaningful disclosure. We also have a deepfake compliance guide and some other research coming out. And we have some standards for our code of conduct that we share with our members about not creating misleading content as the red line, and then kind of fair game for anything that doesn't involve misleading the public on content, but with that rubric for prioritization schema of ethics. So I hope that that's helpful, and I'm happy to talk more about any of those. But
That's a good start,
Very
but we want to
helpful.
hear from everybody else. Yeah.
Of course.
Thank you for having us here today. So I guess in terms of what AI is used for, I think AI is being used by political campaigns right now to save money and work efficiently. I mean, that's largely what it's being used for. And I was thinking in preparation for today, back when I did redistricting, of which I've done a lot in my career, back in 2001, there were probably 15 people in the state of California that had the ability to draw maps for legislative seats and down to using the census data to be able to do that and predict election outcomes. In 2011, it became a little bit more widespread. And now in 2021, basically we had Dave's redistricting app and all these different tools that are able to do redistricting. It's just far more simple to be able to do that. And I would imagine in 2031, I'm already making plans to be able to draw districts with AI. I can put in the criteria that I want, equalized population. We want to respect whatever exists of the Voting Rights Act at that time and be able to create different options for local governments to be able to do. I also think about, at one point I owned part of a company that did robocalls, right? They were the thing, and they were incredibly inexpensive. We could communicate very quickly to a lot of people. And largely, they've been regulated out of existence. I mean, I can't remember the last time I did a robocall just because the disclaimer requirements are so great that it's just not politically worth it. And I think that AI is just quite a bit different because it's not a definite way of communicating. It's a way of creating stuff in political campaigns. And so I think that AI is probably being used by most of my colleagues out there in the world to make their stuff better, whether they're running AI through to improve their writing or to be able to check for spelling errors. And I know that your proposed regulation addresses those sorts of things. But I would also tell you that AI is being used in an awful lot of places. I would imagine that for the legislators that adopted this bill that you're trying to struggle with, I would guess a very large portion of their portraits that are sitting over there in the Assembly and Senate have been doctored with AI to look a little bit better and to be able to maybe look a little bit younger. That's just the nature of the way that works. But AI is going to continue to evolve and be used by campaigns to create things. And so, but for me, I'm not going to have a problem with AI because I'm going to know what the rule is. I'm going to apply it. My campaigns generally have the funding to be able to have attorneys, to have them run by and do a check, to be able to do that. Where I think your regulation is far more likely to trip people up is the smaller level campaigns for city council. We're not talking about major multi-million-dollar congressional campaigns. We're talking about somebody running for local city council or school board, and somebody's doing this to create an ad that normally they wouldn't be able to do. 20 years ago, we paid a ridiculous amount for websites because they were the cool new thing. And now the market has gone to a point where websites were costing $7,500 and $10,000. And I know a campaign that spent $50,000 on a website. That'd be malpractice today. Websites are far less expensive to be able to do that. And basically everyone now can create a website. In fact, now I think AI is going to be used to create an awful lot of websites that exist out there in the political world because it's less expensive. They're driving towards the more efficient way of spending limited campaign dollars. And so I worry that your regulation and Mr. Brandt brought up, Commissioner Brandt brought up the mayor's race in Los Angeles. I think by the time this regulation is put into effect for the 2026 cycle, that's all lovely. But by 2030, I think this market's going to have changed dramatically and even going far beyond that. So I guess I would just caution you all that AI is being used for a lot of things. I know that the intent of this legislation and the intent of the commission is to deal with trying to have disclosure. And I don't actually think the disclaimer, I was very interested in this research. It's actually fascinating to me that people actually follow through with that, because I actually have questions whether voters and recipients of information other than the politically involved are really paying attention to disclosures. The disclaimers, excuse me, to be able to do that. So I don't think that's big of a deal. I agree with your counsel that this is far less likely to be unconstitutional than the other two bills that dealt with the content. We're just simply labeling it. But is that really effective, and what are these legislators trying to do with this? And I know we can talk about that a little bit more, but AI is going to be around and it's going to change dramatically. And one other comment I would make in terms of your initial discussion. I know that you're thinking it's really easy to determine what is AI and what's not, and has it substantially changed or has it not? And everyone knows what a cartoon is. I challenge you all, if you've ever looked at a picture and thought, is that an actual picture or did somebody actually paint that? For those really incredible artists that can do that, and maybe you're laughing at me because you think, well, that's never happened to me. But your definition for material altered, I think, is going to be really difficult, because cartoons, you can say it's a cartoon, but there's some really skilled people out there, and especially with the help of AI, can make things look very, very real that would be cartoons. And so that definition, I think, alone might give you difficulty over the next 2 years. So that's all.
Yeah, I think those are excellent points. And to build on your point in regard to the potential for unintentional violations at the local level,
That's going to happen.
I suspect it will. I'm also concerned that the most sophisticated parties are going to be able to use more advanced tools that are going to make it more difficult for enforcement agencies like ourselves to identify and demonstrate the use of AI. Like, as you pointed out, we're under no impression that it's going to be easy to identify when AI is used. We had a panel where we invited a bunch of different experts. We had Adobe, Google comment. We had another company that specializes in identifying AI, a professor who works on this specific issue. And it's difficult, but we have we understand, the sorts of issues we're going to run into. I think what we're dealing with here today is we ultimately have to act within our authority.
Sure.
So while one of the main reasons I wanted to have folks with your sort of background, Mr. Rexroad, and everybody at this table, is so we could identify the potential practical challenges and implications that are going to be created by a proposed regulation or something similar to what we're proposing here. We can't necessarily just adopt a regulation that addresses those issues and disregards the legislative intent. But I'm really glad that we are getting all of this information on the record. So if sometime in the future the legislature goes back and reconsiders this, they have this all ready to go so that they can look at it, and then we can consider it in potential future regulations as well. But that was tremendously helpful.
Mr. Chairman,
Wexler.
can we get through, I want to make sure each of them get time, so let's not engage them
Sure.
first, okay? So I just want you, I mean, if that's okay, and then we can engage and go back and do that, but I want to make sure we
Go
hear from
ahead.
them.
And I don't have
Opening.
a speech, I'm here with Casey. so-
Okay. Oh, so you'll just be the one we ask questions to.
And,
Okay.
and until we get into the nitty gritty of the regulation, I'll keep my overall comments brief at the start. But what we want to see is more to recognize instances where a committee is not necessarily looking to depict something that didn't happen, that isn't necessarily a nefarious purpose there. It's that it's going toward efficiency. It's that the committee is using AI to replace the tools that they used before AI existed. Voiceovers are a common example, changing backgrounds for certain speakers. Those have been involved in political ads forever. And now with the existence of AI, it's more efficient and quicker to use AI. Even I believe Adobe has an AI feature you can use when it previously didn't, I don't know, a few years ago. So we want to see a recognition of that in the regulation, and hoping that we're able to craft some language that accounts for the fact that committees are using these to make an end product that, again, is like a regular campaign ad. It's not always trying to be for a nefarious purpose. It kind of goes to what we used to call editing, just regular Photoshop editing back in the day. Again, I have more specific comments into the language of the regulation that I can hold for now, but that's our overall theme. And we would love to see, I don't know if we can get there, but a list of specific uses where, I know we all love specificity. We're lawyers, we like that. I know enforcement probably would like that too. Specific instances that do and don't require the disclaimer. If we could somehow work that into the regulation, that would be great.
May I follow up quickly on what you said about the voiceover, which I think is important? So it used to be the case that we would go online, we'd listen to people's voices as examples, and then we would say, oh, we like Casey's voice. We're going to use Casey, and we'll have her tape the audio for our radio commercials. That doesn't happen anymore. I go online, I listen to a sample of Casey's voice. I like her voice. She licenses her voice to be used, and we simply use AI to say what we want Casey to say. AI creates her voice. It's with her intent, but AI has been used to create this spot. I could have paid her for that to actually talk into a microphone. I no longer have to do that. I simply tell her voice what to say. That's the voice I want, and that's what I deliver for my client. We could have had her do it in a microphone. We didn't, but I believe because it was wholly created, or her voice was wholly created for a radio spot or whatever I'm going to use it for, it would trigger a disclaimer. But I'm just trying to use it efficiently because I'm going to save money by not paying Casey $300 an hour for the use of her beautiful voice. I'm going to pay her $50 for the license to be able to use her voice to do that. I don't know that the legislature intended for those sorts of circumstances to require a disclaimer. And then as I listen to this presentation, now I have doubts whether I'd want to use Casey's voice, even though that's the cheapest way to do it, because now I have to put a disclaimer on it, and voters may not suddenly like what I'm saying in that radio spot especially if it's a positive spot saying great things about Silver for Congress or whatever I want to do, it's going to be discredited by the voters in some way.
Can I add a little more to that?
Yeah.
And to segue off of that, I think that's going to go into more as we get into what is entirely created versus materially altered. Like, let's say that voice is used and it's used in the background of a video ad, and that's the only AI used. That the whole rest of the ad is shot by, I'll call it old-fashioned, a video shoot. Is that entirely created, materially altered? When there's that little piece of it in there, when the voice didn't exist, it was completely made with AI. We see it often with songs too. I know there's a lot of copyright issues using different artists' songs. So when you can instead make a new song in AI for little to no money, and they do a pretty good job at it. So those are other instances, and we can get into the nitty gritty of the wording, but other instances that are coming up too.
And the last thing, if I may, just kind of add to the use cases where the use of AI could drive down the cost of campaigning, lower the playing field for more candidates, and enhance the quality of content that the public's seeing. Another use case is translation. And that may fall into an area that could benefit from additional specification, especially in a wonderful state like California where there's such a diversity of languages spoken. We did see in some of the initial tech debriefs that we did with campaigners in California that AI was used quite extensively for translation, which we saw as a very wonderful use case for accessibility of information and reaching out to voters. So we would just ask that that is also kind of considered when we're looking at the specificity, especially with the second piece around tools that are used for grammar and the textual pieces. Overall, I think these are great use cases of AI driving down the cost of campaigning. And who doesn't want to receive a few less fundraising texts because it's cheaper to run campaigns, right? There's a lot of ways where the use of this transformative new technology could benefit the quality of campaigns that the public interacts with. It makes it easier for more people to raise their hand and run for office. And so I think the challenge today is how can we support the nitty gritty of campaign operations and how these tools are being used by campaigns on the ground today in a way that separates the use of the technology for campaigns with the effect of the disclaimers on the use case. I think that's the piece, because I think right now what we're seeing in some of the empirical evidence is there's all these healthy inbounds ethical use cases that will be impacted by the presence of the disclaimer. And the spirit of the disclaimer is really around identifying use cases where deceit could be a factor to help encourage the public to apply an appropriate level of scrutiny without being misled, given that these technologies are so transformative in the believability of content. So just to kind of bring it back to your question too a little bit from earlier, as we look at these use cases, the environment where they're being deployed, and the effect of the disclaimer versus the potential good and bad effects of this new technology stack, would just offer perhaps the interpretation could be that it's not that the reasonable person is required to be an expert in discerning whether or not AI was used to a certain extent in the production of a piece of content, but that the reasonable person could draw a different conclusion about that candidate as a result of seeing the content that's not accurate. And so then it's less about the reasonable person discerning AI usage and more about the reasonable person coming to a different conclusion that's unfair to that candidate. And so just kind of offer that as a perspective when we think about where reasonable is most important. I think it's in being a barometer for being misled or not versus discerning the content itself.
Mhm. Great. Mr. Wang, go ahead. Thank you so much for joining us today.
Yes, good morning. And I apologize when I called in on a phone number, you could not hear me earlier. But good morning, Chair and Commissioners. My name is Ken Wang, representing the California Initiative for Technology and Democracy, which is a project of California Common Cause. Cited, as it's known for, it was created to address the threats of emerging technologies posed to our democracy. And we sponsored a couple pieces of legislation that, Chair Silver, you mentioned, parts of which have been enjoined by the courts, but we also support the broader goal of increasing transparency in our elections, which is shared by the Commission, and also the regulations that we're talking about here. As to the questions around kind of reasonable person, what is material, I think some of our other work around generative AI provenance, digital content provenance, I think may be instructive here. There is a law on the books now, the California AI Transparency Act, that would require content generated by generative AI to contain latent disclosures, that's invisible identifying markers to kind of identify when something has been generated by AI, either kind of wholly or substantially altered. And I think that is kind of instructive here, because contained in that law, there is a definition for what constitutes minor modifications. So that is Business and Professions Code 22757.1. So that might be helpful in thinking about kind of what may be material. Now, as we had worked on that sponsored that legislation, have continued to work on tweaks to it, we also grapple with kind of what could be considered material, right? Like thinking about some kind of just beauty filters, for example, and kind of the example about the assembly and senators' photos. Sometimes in 2024 election, age was an incredibly material issue in that election, and what may be captured under a minor modification exemption, might kind of let use cases escape disclaimer when we might want kind of, additional transparency, right? But I share kind of the fellow panelists in kind of the concern, awareness of the kind of impact of AI on kind of political campaigns, both good and ill. But I'll just say that kind of the scale and efficiency that AI enables kind of actors, even just for very little cost, to manipulate content where otherwise, one might have to devote hours and hours to Photoshop and to manipulate an image. Now you can do in mere seconds or for very cheap, I think is a different kind of scale in terms of the problem that we're trying to address here, which is why I think kind of the regulation, that why we continue to propose and advocate for regulation and legislation to address the specific harms that these tools might pose. And I would also, the last point I'll make is that the kind of definition for what is authentic, I would just offer that while not adopted into legislation, there was a piece of sponsored legislation, AB 3211, again addressing content provenance. In one of the versions of that bill, there was an attempt to identify or to define what authentic meant. And I just offer this as kind of maybe a suggestion. Authentic content means images, videos, or audio captured in the physical world by a natural person using a recording device as kind of the starting point for how we consider kind of authentic content. There's kind of course, issues there too, because, cameras, phone these days, there's kind of embedded with AI in it. But that was our best attempt at the time to kind of describe what exactly we mean, right? It's like things that have happened in the physical world and that have been captured by a person is different than things that are generated based on a text prompt or kind of altered by a generative AI system. So those are my kind of 2 cents. Happy to answer any questions.
That's really helpful. Did Cited take a position on AB 2355? Do you know that? If not, no problem.
I don't believe we took a position. We monitored because we had these 2 kind of parallel sponsored bills around addressing specifically deepfakes. So we didn't weigh in particularly on the disclaimer component of it, but our kind of work on digital content provenance emphasizes the importance of disclosure and transparency in the form of kind of the provenance information, right? So I think that is our hope, is that is the infrastructure that undergirds other kind of disclosure, disclaimer requirements, that there is a kind of ground source for truth. There are issues with kind of digital content provenance also that kind of companies are figuring out. Like our bill around content provenance was in collaboration with the industry, with the Adobe, with the Microsofts and Googles of the world, right, where they're implementing this technology. But we hope that the content provenance is the source of truth for kind of other bodies such as yourself to consider when regulating on top of that existing infrastructure.
That's helpful. Well, thank you for joining us today. Commissioner Brandt?
I'm just taking in all these things and want to get your perspective on ways we do and what do we do this year. I mean, it's changing so quickly. And, I have to say, on the allowing small campaigns to use AI for a whole range of things, that is also in the judiciary. One of the programs we're doing right now, or we're developing right now, is for a court that we're getting slammed by all these AI created pleadings and defenses. And it's often people who don't have, it's the self-represented litigants. But they're getting access. They're able to make the arguments by having the law, and then the courts are they can provide the law. They can't provide legal advice, but they can provide the law. So they're using that, and then they're taking it, and it's in often in these huge number of cases of debt collection and eviction, all those kinds of things as well. So they're doing these things, and it's creating access to justice. But then what do we do? What do judges do with that? Can they, anyway, so then it's a whole other thing we're doing. But it kind of similar to that of these small campaigns. And we want to promote a vibrant, vigorous campaign. And so we want to support, in some ways, AI being used. And I think in some ways, I guess we should go to questions. Maybe we go back to deception and sorry, I've just got a lot of different things. Let me ask these questions. What do we do this year to incorporate, if we focus on deception, focus on specific kinds of disclosures? In other words, just not saying everything's AI created, because that's going to be everything and the meaningfulness of this. Maybe we identify, you decide what it is. I mean, at this point, if you've done one of these, you're fine. And then we are careful on enforcement because we're trying to get to that deception. And I don't know whether we can do something like that, but I'd kind of like to hear your views of what could we do to help the political community tell the public, well, this is because you may want to. And the question is, yeah. So how do we do this? What can we do this year to start that conversation and see how it goes, but support you using AI, but disclosing it when it's substantial? So I mean, that's not a word in here, but help me. What can we do? What kind of regulations can we do?
So assuming no objections to this approach, what do you think about this? What if our general counsel lays out what we see as the options on the table, and then we hear from our experts as to what they see are additional potential options for applying the statute via regulation, right? And then we kind of consider those. One example that I thought was excellent that Mr. Rexroad brought up was the example of Ms. Jenkins' voice, right? So let's think about using Ms. Jenkins' voice for a campaign. So Mr. Rexroad wanted to use her voice because he said it was beautiful.
It's amazing. Yeah. You heard her. I mean, how can you deny that?
So that's why it's being
To
used,
license my voice.
because it's essentially effective for the advertisement, right? It's a favorable a voice for the advertisement. I would see it very differently if Mr. Rexroad was using Ms. Jenkins' voice and then saying, campaign finance expert Ms. Jenkins says, whoever for assembly accepted this illegal gift, something along those lines, right? I see that as a very different thing.
So may I offer a thought on that, please? This is actually the main thing when we talked about this that I think is important. I know you've worked in the legislature, Alf. That's where we first met. Mr. Silver, I know you worked there. I know you worked with plenty of legislators. I don't know her as well, so Hillary may have other experience with legislators, but what's that?
We're new friends.
We're new friends. Yeah, I might join the AAPC as a result of your presentation. So, but I realize that this isn't in the legislative history, but I would just ask you to consider, knowing legislators that you've interacted with and what are they upset about? They are not upset about making their campaigns more efficient. They don't want that. The outrage on this, and I would say that the memo that was written by either Mr. Bainbridge or Mr. Norton, which I think was very well done, it talks about increasingly simple to produce false and misleading synthetic media that closely resemble authentic content. Well, I believe that even when I was trying to define the definition of deepfake in anticipation of coming here today, I believe what they were fighting for is false statements made about your opponent, not statements made about you. And your example of Ms. Jenkins' voice is a perfect example of that. And by the way, I don't know that you're ever going to find and be able to regulate, because nobody's going to complain when I produce something from Ms. Jenkins that's positive for her. You don't know whether it's her voice or not. So how will anyone bring that to your attention? I don't know what the problem is there, and I don't know what the harm to the electorate is. And I know that it is not authentic. I created it. But then again, it appears authentic because it's actually her voice. Where the problem is, where every one of these legislators, in my opinion, is upset, they want to prevent somebody from saying something, making it appear as if they said something or something was created about them that misrepresents their record, the other campaign's appearance. I think that's really, for me, the definition of deepfake, and those were the terms that were used in the debates about these pieces of legislation. I believe it even is reflected, and I acknowledge it could go either way in this memo, but that's what people are upset about. Nobody is upset about my example of using her voice, and actually if she's the candidate, using her voice, or me creating a TV spot or a video that accurately represents my client's opinions or views that I could simply have recorded with an iPhone, but instead I'm using an iPhone to be able to do that. I just don't see the harm with that. I don't think the legislature intended to regulate that behavior. What they would be upset about is me putting words into Mr. Silver's mouth, saying that he supports or opposes something that he didn't, and he's the opposing candidate. That's what they're upset about. And I truly believe that that's what the legislature was seeking out to regulate when they did that. Is it in the legislation and they passed in 355? No. But I absolutely, and I think I would just ask you to just use your common sense in terms of the legislators you work with. What would they be upset about? They would not be upset about being able to use their technology efficiently to produce their campaign material. They're upset about somebody lying about them. That's what they're upset about.
Commissioner Brand, then I'd like to go to General Counsel Bainbridge. Go ahead.
Before that,
Yeah.
I want to have some. I want to have some back and forth on this one because so I'm looking at the statute and I'm focused on maybe we focus the regulation on different words than where we've been focused. So based on your comment, looking falsely up here, maybe that's where we focus. It's about falsely up here on it's entirely created by artificial intelligence. And some kind of that it's false, it's a lie. I mean, that's the thing. And it goes back to the deception part of that thing. So maybe that's one. And then the other one, have fundamentally different understanding. And maybe, we focus on those words because that could mean it go back to deception, go back to, it's not just materially altered. And maybe that's the less important words now. And we focus on fundamentally different understanding and that means it is false or it is. So anyway, so I don't know if you want to respond to that or those kinds of things. In other words, I think we go back to it's about deception. It's not about that it's different. And that's where, like that example that you used where you're using her voice. Do you have a fundamentally different understanding? I mean, that may be a one piece. It's not completely, that visual or audio media is entirely created. It's not that one because you're just, you're creating, that voice is the only thing that's doing. So is it materially altered? Yeah, okay. But the alteration would cause a reasonable person to have a fundamentally different understanding of the altered media. Does that, I mean, I don't know that would apply to that kind of situation where you're using her voice because I don't know, fundamentally different altered. Okay.
Yeah, no, that makes
Sorry.
sense. I keep forgetting to do this, so I want to do it right now. I want to disclose my ex parte contacts related to this. As I mentioned, I really feel like it's critical that we understand the practical implications of this law and our potential regulations. I've never been a campaign consultant, for better or worse. So I don't completely, I'm not familiar with the intricacies of putting together a mailer or a digital ad. So I reached out to several different campaign consultants. I spoke with Jacob Bytel, Derek Humphreys, Matt Rexroad, who's here with us today, Bill Wong, Kevin Reikus. I also spoke with John Bennett, who's the executive director over at Cited, which is a project, as I understand it, of California Common Cause. As to Common Cause, I spoke with Sean McMorris, who is an analyst over there at Common Cause. I spoke with Professor John O'Brien of Cal, who specializes in this area. I spoke with Ms. Lair. I spoke with Nick Sanders and Tracy Wigglesworth of Political Law Group. And I solicited feedback from Casey or from Ms. Jenkins, but I don't believe that we ever discussed the proposed regulation. So I believe that's all I have in terms of ex parte. So now I'm going to throw it over to Mr. Bainbridge, unless Commissioner Brandt.
Thank you for all that all that work on ex parte work to prepare for this. So because we really did want to have this, and so I appreciate you preparing for it.
Of course.
So what are we talking about what
Sure.
Mr.
I think it'd be
Rexroad
helpful
said?
just to lay out what we believe our options for here, or we can even do it simpler than that. We could just say what the options are that legal so far has proposed for interpreting the statute, right? And then we could open it up to the group to get their feedback on our proposed interpretation, and as to whether they have any other proposed approaches to it.
Okay, yeah, what we have in draft so far, we haven't really put forth options. We've put forth our best attempt at defining some terms. I think to the specific point about the voice, that's an issue that we really have started to think about and really try to address just in recent weeks. And when we started, I had mentioned that we're going to be suggesting a definition of what is entirely created. And in my way of thinking would be where you take someone's voice, you have existing voice, and you use that to create an ad. That wouldn't be entirely created using AI because you're taking existing audio and modifying it. So where I think we're headed, at least as staff to present to the commission, is that would fall under the second prong of being an alteration. And then you look at what is it a fundamentally different understanding? And I don't see a fundamentally different understanding. I think you've used the person's voice to say something, and whether that voice was created by a computer or it's their natural voice, it's not changing the message of the advertisement from my perspective. So I think that's where we would like to see the interpretation go, and that's what we're going to be proposing. Again, we're kind of in the early stages on the language, but that's why we were thinking one way to do it would be to focus on to be entirely created using AI is based on a text input that then creates the entire advertisement. I would love for the AI people to tell me that is a good or bad, or have better suggestions, but that's sort of what we're trying to get at, where you're not modifying an existing voice, you're actually creating everything out of whole cloth.
Okay, so here's the other question in response to that, if I may, Mr. Chair. So right now, I know these voices because I've used them before, and I know that they exist, and I've used them for other advertising. But pretty soon, it's just going to say Casey, and I'm not going to know Casey. Casey could be an creation entirely. I mean, these experts have the ability to create voices, and so this cycle, I'm pretty sure who those people are. But next cycle, I'm not so sure. They're just going to call it Casey, and I don't know whether Casey exists or not. I don't know whether it's wholly created or edited from her sound files that they have. And so I'm probably going to know because if Casey's real, I'm going to pay more to license her voice. If Casey's not real and is a creation, I'm going to pay probably a reduced fee because they haven't had to actually pay Casey any licensing fees. But I'm not going to know that as the consumer. And so will I put out ads that don't have a disclaimer without knowledge?
Okay, but what I'm hearing from him though is it's not a problem because Casey, okay, if it's a visual commercial, on a TV, then that's one piece. It's not entirely created. So it's one piece is entirely created, but the whole commercial is not created.
It's a radio commercial.
Right. Okay. So I'm getting there. So if it's a radio commercial, yes, but then you go to falsely appear to be authentic. And so I think the falsely appear is where we need to talk about what makes it false. In other words, it's a radio commercial, and yes, it's entirely created her voice, but is there some deception? Is there falsely? That's the thing that I'd say that we need to focus there. That's where we're, does that make sense? And yeah.
It does. And so I read the report that your organization put out, Ms. Lair. And I think what was interesting approach that you've taken to this is you look at whether the use of AI is evidence for the assertion that's being made in the ad. And that kind of goes as to whether, I guess it's in the public's interest, what have you, good best practices for there to be a disclaimer. So I think what Commissioner Brandt pointed out is an excellent point in terms of falsely. I think if the legislature sought to have a disclaimer on every single political advertisement that was entirely generated using AI, they would have just said the visual, audio, or media is entirely created using AI and would appear to a reasonable person to be authentic, right? What is falsely doing in this sentence? If it's just, if we're just worried about whether something looks authentic, whether it looks like clip art of the Capitol, right? Then I would suspect that they would have left out that falsely. That falsely points to some sort of deception, what have you.
Right.
Right. So our question is, how do we want to construe that word, like Commissioner Brandt laid out? And is the AI, like we talked about with the example of Ms. Jenkins' voice in this circumstance where you're highlighting her statement, her artificially created statement, as being from a campaign finance expert, is that falsely creating the appearance of something that's authentic? I think it does. I think it is, versus something versus just using her voice as another person, where you're not attempting to deceive the recipient.
I would definitely concur here, and I think the presence of the word falsely implies that the effects that we want to protect the public from are the effects of misinformation, not the effects of technology used ad hoc. And so the presence of the term falsely to me indicates that the real issue is a relationship to truth, and that's what the public should use assistance from us in ascertaining. So I would say when we start to look at authentic record as a term, one recommendation would be contains a realistic depiction of something that did not occur that would falsely appear to a reasonable person to be an authentic record. Then the voice example would be in the clear. If it's a translation, if it's something that somebody wrote and then used a translator to produce, or an AI vocalization tool to produce, it doesn't mislead the public on something substantive, it's probably within bounds. And there are already many examples of this type of digitalization of a resource that doesn't mislead the public, but is just a technology-enhanced efficiency for campaigning that has been used long before the existence of AI. So I think the relationship to truth here is a good differentiator on what enforcement might want to prioritize, perhaps. And I think the clause for 12B says or does something that the individual did not say or do is the right qualifier for that differentiation. That frees up folks in the political space to use great new tools to create content that informs voters. It probably provides space that's within bounds for satire, for translation, for persuasion, which are all types of political speech that are necessary for campaigning, but helps to draw the line at deceit, which is where I think voters do expect an intervention, and where there's existing precedent and legal precedent to intervene when there are falsehoods perpetuated about a candidate. So that if it's helpful to a certain extent, I think it's less about the use of AI and more about the presence of deceit.
That's very helpful. I know, Ms. Jenkins, you were going to chime
Yeah,
in.
no, I sort of wanted to, there's been a lot of talk about the voiceover state, but I want to flip that on its head a little, like, because we've seen an instance where, like, let's say there's a video of a person that is real, unaltered, unedited, filmed and aired exactly as they were. At the pre-notice discussion in May, the commissioners discussed backgrounds a little bit. And I want to dive into that a little bit, because if an entirely real, unedited, authentic video of a person saying something they actually said, but the background is all done by AI, the background music, where they're in front of, etc. Obviously, how an ad is received differs if it's happy music versus scary, dark music. That can change it. Again, you guys, the commissioners discussed putting in front of different backgrounds. And so, which kind of flips the voiceover thing on its, just kind of the inverse of that. And I wanted to raise that too, because I think it was acknowledged back in May that the background can make a difference. Are you just putting them in front of the background of,
Yeah.
And so when the actual person, they're not being depicted saying something they didn't say, because they did say it's how they were filmed and they said all those things. And then there's that, is that editing? How does that come into it?
And I think
Throw that
I
out there.
kind of, right, and I think I kind of step back from that. I mean, after hearing you today, I don't think background, I mean, is it false? I mean, maybe there may be some cases where you're putting them in a place that they never were. And it's what they actually said, but it's creating a false impression or doing something like that. But you're right, backgrounds, yeah, all that stuff at this point, I'm like, yeah, no, none of that stuff matters to me. So, and I like your approach of it's not about the use of AI, it's about the deception. And it's about that kind of thing. So I think you're right, because I think I've thank you for coming, because you've been part of my evolution of this. That's why I wanted to have this meeting, so we could go a little bit deeper. And so, Council Bainbridge, do you have any thoughts about how we can move this to deception and create? And also, my question is, I want to create a structure this year that allows for them to choose. In other words, we're not ready, and I don't know that we'll ever be ready to define, and this, these kinds of things, there's going to be a lot of creativity in how they use it. If we focus on deception, we give them options, I think based on the report, give them options for how they disclose. In other words, you need to disclose some way, and I haven't focused on that provision, but they can disclose, they can be specific and say, this was created by, we did this. So it's specific about some kind of disclosure, so the important part is not, this is AI created. That's not the disclosure. I want to, anyway, yes.
I have two thoughts I want to share. Do you want to go first?
No, go ahead.
Okay. First, I think deception is an interesting standard to consider, because I do think that's what the legislature was trying to get at, though they didn't write it that way. But we also have to be careful not to creep into the whole point of political ads is to influence, is to create an impression. The candidate often isn't going to like that impression that their opponent or an independent expenditure committee is creating. Whether AI is used or not, it doesn't matter. People aren't doing ads to just throw them out there. They're doing them to influence a voter's perception of a ballot measure or a candidate. So the fact that they're trying to be influential or create an impression, that's really tricky when you get into, well, what is deception versus what is just influencing their opinion of a candidate. That's the whole point of all of this. But what I wanted to focus in on is, because I'm the lawyer that the consultants come to, tell me what to do. When do I need a disclaimer? When do I not need a disclaimer? Sometimes they'll decide not to do an ad in a particular way if I tell them that they need a disclaimer. They might figure out a way to do it without AI so that a disclaimer isn't required. And so, Commissioner Brandt, you asked earlier, what are we doing here? What is the goal of this project? What kind of regulation should you be creating now with the statute that you have? I think the discussion that we've had today reveals that the legislature may still have some more work to do. I think the FPPC could be a good partner with the legislature, saying we've had these hearings, we've had these discussions, we've had these ex parte communications with people who actually have to grapple with this and figure out what it means and apply it in a product. So the legislature may not be done, but what we have is a statute, and we have an election coming up. And we've had an election where we've had to grapple with it. I have a client who had a complaint filed against them that is sitting over in enforcement. We haven't heard back what enforcement is going to do with it. And that particular ad raises some very interesting practical questions. And so I think the regulation, the goal here should be, what does the statute mean that we've got? And we may not be able to get all the way there, but can we come up with a regulation that gives us really practical, we know what this means, guardrails? And you might be squeezing from both ends. Oops. You might start with, these are scenarios where we think the AI disclaimer clearly applies. No question, you got to have a disclaimer on it. On the other end, you've got things, cartoons, for example, where you clearly don't need a disclaimer. In the voiceover example, some of the questions we've gotten from consultants is, well, what if we've just created this voiceover and these people are just anonymous people? They're not identified by name. It's not Adam Silver and Alf Brandt talking to each other in a radio ad, and they never had that conversation. It's anonymous female voice and anonymous male voice, husband and wife talking over the dinner table about Protect Prop 13. We've all heard these ads. Do you care who these people are? Do you care if they're real? A real husband and wife? You're never told their names. You're never told where they live. Maybe their voices are real. Maybe they recorded them in a radio studio. Maybe AI made it up. Who cares? Does that need a disclaimer? Maybe you could say on the other end of the spectrum, no, that doesn't need a disclaimer. So that's what consultants want to know. Do I need a disclaimer? Do I not need a disclaimer? And I think we might end up where there's a gray area in the middle that we don't know the answer to that. And then we have to decide, we got to go back to the legislature and work this out some more. you're going to take a light touch on enforcement for these middle grounds because we don't really know if the legislature intended to apply to those or not. To give you some more practical takeaways here for the general counsel, look at the terms in the statute that we need to define. I think we've already talked about some of them. What does entirely created mean? Does it mean an entire 30-second radio ad? Does it mean the whole mail piece front and back? Does it mean a photo in the mail piece? That photo was entirely generated, but the mail piece wasn't entirely generated. The text was written by a person. They typed it, or they changed the font, or whatever. So what does entirely created mean, I think? And everybody here has pointed out the word falsely in that subdivision. And so that can be helpful in defining what that means. Materially altered is another thing. That's where you're taking something that exists in reality and has been changed by AI. But what about like the voiceover that's wholly created? It's kind of not covered by subdivision 2i or 2i. If we're taking the position that the whole commercial, say a 30-second TV ad, wasn't created by AI, but the voiceovers were. So is that a subdivision 3 that they didn't write? Is it not covered because it's not referenced at all? It's made up, doesn't create a false impression in any way. Nobody cares who the voices are. We all assume they're fake anyway. Doesn't need a disclaimer. So like trying to define what these phrases and words mean. Another one that I haven't seen discussed, but that directly applies to the particular one that I have stuck in enforcement is in B, cosmetic adjustment, color edit, cropped image, or resized image. So the one that I have sitting in enforcement.
Ms. Tice, I apologize for interrupting you. I just want to make sure that we're not bias
We're not.
prejudice as to any complaints.
I'm going to give you a hypothetical.
Okay.
You have a photo of a candidate that's real, and the background was changed with Photoshop, but not AI. Purchased a stock photo, stuck it in there. This disclaimer wouldn't apply. But the color of the chair that the candidate is sitting on was changed. So is that a color edit, a cosmetic adjustment? Is it not one of those things? And so those are the sort of practical scenarios that consultants are using AI to be more efficient, to do stuff that used to take them hours, now takes them minutes or seconds. So where does this disclaimer come into those sorts of scenarios? What is a color adjustment? What is cropping? When does it cross over into creating a false impression versus just being an artistic license? And so that's what the lawyers want to know, and that's what the political consultants want to know is, what do these words and phrases mean? So I can decide I'm going to do the ad that way, I'm going to use AI, or I'm not going to use AI because it might affect how voters receive what I'm sending them. They might not trust the media if I have to put this disclaimer, so I'm going to do it a different way. So these are the kind of questions we're getting asked.
I think those are very important questions. And I think the approach that we want to take with this is a collaborative approach where we consider those sorts of examples from the regulated community that they're seeing in real time so that we can consider, provide you with feedback on them. Our issue is that we hadn't received those sorts of examples up until this point. We still don't have really a wide breadth of examples from third parties. So we've been creating examples on our own. And then we didn't get any feedback from anybody on those specific examples or our interpretation. So I'm hoping that moving forward, we can really identify those sorts of potential pitfalls, issues, et cetera, so that we can discuss them as a commission like we did at the May meeting, and then get feedback like we typically do from various different groups, whether it's Common Cause or CPAA, on how they would recommend defining certain terms or interpret certain situations. So one thing, and I'm going to kind of put you on the spot, but of course you can decline. So do we think it would be helpful to have presumptions of certain situations? Do we think presumptions would create issues for us? If so, would CPA be interested in providing us with specific presumptions? So I've been looking at the language here, and I think there's a standard that we can create that is going to cover or create a clear analysis for most situations, right? But I don't think that standard that I'm still formulating would address situations where perhaps we adjusted the age or skin tone of a specific candidate. So I think what I'm getting is I think there's certain situations where a broad, clear standard would be helpful. And then I think there's certain situations where perhaps we want to have a presumption as to a limited set of facts.
Yeah.
And in order to get there, we're going to need feedback from everybody. So I'm really hoping we can do that. With that said, I want to get back to Commissioner Brandt's question in terms of this year.
Right.
So it's July, in the middle of a midterm election year. We are considering this for adoption at our August meeting, I believe. So if we were to adopt this in August, Executive Director West, General Counsel Bainbridge, are we recommending that this go into effect before the general, after the general, and then thoughts from the panel on that approach? General, would it be helpful to have a regulation in place before the election? Go ahead.
Okay,
Executive-
yeah, so I want to get there before you answer. First of all, yes, the legislature has to, I mean, the world has changed in 2 years, right? So that is a given. Yes, the legislature needs to do more work. So my view, our goal in some ways is to take this year, and yes, something applies this year because we need to learn from what's happening this year. And so I think that that's the goal, and I think you have a good approach. First of all, on some of your questions, what is entirely created? I think you need to look, I think the whole approach of this is the entire thing. It's not the pieces of it. So, so that's gonna be a high bar about something that is entirely created using artificial intelligence. So it's not the pieces of it, it's the entire, and so I'm gonna treat visual or audio media as the whole thing. That's the first thing. Second thing then, looking at the visual, materially altered, alteration would cause a reasonable person to have a fundamentally different, and I want to see us say something about, in the regulations, about that fundamentally altered is deception, or is something that is, fundamentally different understanding is about deception and something along those lines. And then I want to have the regulations for this year give some flexibility. So we're not defining what the disclosure is, and I think we also define the things that are, that's all fine. And then the things that are, that's exactly what we're trying to get to. And then take a stab, and that's where you can really help on what is that gray area? Where is that? And we may not, be careful here. It may be difficult, just to make this observation, I'm not making this comment as the commissioner, it may be difficult to enforce something in the gray area this year. But doing it this year and having it take effect is going to help you and us work with the legislature in the coming years to refine what it is they're trying to get at, and what we can do, and how much we can do. And it's going to change, but how can we do some things that allow for that change, allow for that creativity? So, and get to the part of what they're trying to get to. So that's kind of my sense.
We'll get to you in one moment, Mr. Rexroad. I just interested in General Counsel Bainbridge and Executive Director West's take on the question presented, which was, is the recommendation that we implement this prior to the general or post-general?
I'm not sure that it's all that important. I mean, I think the point of this regulation, and I haven't said this in 14 years, but I largely agree with Ms. Titus here.
Agreed. Come on.
Well, there's some things I don't agree with. Yeah. We're trying to provide as much clarity as we can as to what needs a disclosure and what does not. I think that's in everyone's best interest. That's what we're trying to get at. We're not creating any sort of additional rules that I think are going to trip people up one way or the other. I also think, as is always the case with new laws, especially difficult ones to interpret, there is some grace given on the enforcement front. If something's clearly a violation, that's one thing. But if it is in this gray area, enforcement through the years has typically not enforce things where it wasn't clear what the law is. So I think if it went into effect, technically speaking, it would go into effect just before the election based on the timing of when regs become official. I would say that the commission, just for clarity purposes and to keep it clean, should have it go into effect after the election. However, I think having it in place would provide guidance to the people advising on how these ads would work. I think it could go either way. That would be my recommendation.
And I think that then it also, if we put them out, then that gives you the chance to be talking to us afterwards about, and this happened, and this might have been a violation, but it wasn't. And of course, you would always say for your client, this would not a violation, but I can understand how there are questions about this, or this is vague, or those kinds of things. So I think I agree with you. Okay, I'm willing to accept that we don't have the time to get this in effect. But I think that adopting it, because we need this year, we need this experience of what we do this year to know what happens. And maybe we support, or I don't know, this is not a regulatory agency. So, but we support those who do disclosures, and it may be in your interests. I mean, in other words, you may decide that we want to tell people, this is a dramatization. I mean, it's like, sometimes you see those, this is this is that. It's not that, but that kind of thing. And maybe you want to do that. Maybe you want to follow the regulations, even though they're not in effect.
If I could
You're smiling.
We had one put, this is not AI generated, this is a real picture on one mail piece.
Okay.
Because
Well,
I asked if
for
the photo
instance-
was AI and it was actually real.
Go ahead, Mr. Bainbridge.
I would just add, there's always option to ensure compliance, which is including the disclosure. I understand what's been said here and why that's not a perfect solution. If there is concern that there's a way to ensure you don't violate the law, which is including the disclosure if it's in the gray area.
A fact sheet is an option too, short of a regulation. It tells the public how the FPPC staff sort of are interpreting this. I
Yeah.
don't know that you have time to produce that either.
We also can't create law through fact sheet.
Yeah,
So
no,
I
I
think that's why
understand.
we're trying to get this step first where we
Yeah.
get guidance from the commission.
Right. And I think that that's what we do need to create the regulation, because that's actually maybe a step to creating a fact sheet, because we need to see what you do with those regulations. Even though you're not having to comply, but you may choose to comply, but you're going to be doing the analysis, this year for yours. So.
Executive Director West.
Just to give the enforcement perspective, remember they asked for this clarification, so they also want for cases that are pending for everything that they're going to be challenged with this election. They would really like these rules in place so that they have this guidance, so that they know how to move forward, because enforcement doesn't want to be the interpreter of a new law and be the ones that stick their necks out and go, hey, commission, guess what we decided? They want guidance and they want to know how to do things and how it's already been said to the public and how they're going to be interpreting it as been told by the commission. So yes, we would like this regulation to move forward to give us some starting point and to get these examples, because yes, we definitely want to do a fact sheet and we want to do examples and we want to get everybody on the same page, because as General Counsel Bainbridge pointed out, we're not making any new law with this regulation. We're trying to give very clear interpretation so that everybody can apply it.
That's helpful. And I think it's going to be tremendously helpful, potentially to, a certain extent, more helpful than even the regulation, to have the commission provide their feedback on specific examples that are provided by the regulated community. So the enforcement division can hear where the commission is, and in terms of this law, proposed regulation. And so the regulated community can understand where the commission is as well. So we're looking forward to getting those examples, so we can build on the examples that we already have that we presented at the May meeting.
One more thing to add, just to what's the goal, where are we going? I understand why everyone would like a clear list of everything that is or isn't okay. That's impossible with a reasonable person standard. It's necessarily a fact-specific evaluation. As the law evolves, we will get specific fact patterns that I think will become useful in building an area of law. That doesn't help you with your questions you're getting from your clients today. But I think we're trying to create, and this is not, no illusions, this is going to be perfect. It's going to be better than nothing, at least is the lowest standard that I have for regulation we have in mind. I hope it provides some guidance. I think it will need to be adjusted, but I think having specific answers is just impossible given the way this statute is written and the various permutations. I mean, we can sit here and come up with different changes to different ads all day, and it can definitely change how the statute's going to be applied.
Could we though? Okay, not in the regulation. I understand that, and that's the thing. It's changing so quickly that the situations of what we do even this month may be different than what we do in October. So, but could you help us give guidance to the community and perhaps having a conversation by posing hypotheticals to us and saying that doesn't sound, so that we have this conversation. It's not law and it's not regulation, but it's a sense of where we're going and where we want to do, and that maybe that would be helpful. Would that be helpful?
I would just say, I don't know if Commissioner West is smiling, but that was her initial idea, is to bring a number of hypotheticals to the commission and get their input on how they thought a law applied in that situation. So yes, for adoption, I think we brought a few examples previously. I think we can bring more. If people here want to provide us additional examples, we can bring them, get the commission's take on it as they apply the proposed regulation to what the example is. I think that'd be very helpful for everyone involved to have the commission on the record.
Let's do that. So, but that counts on you guys.
Mr. Rexroad?
I have 3 points that I feel I need to raise at this point in the conversation. One is, I don't actually care when you put this regulation in place. It's actually not really going to change my behavior at all, and I think that's true for most of my colleagues out there. But I would say, though, that you're a complaint-driven organization. The only time that people are going to complain and file something with you is not when I put my candidate in a good light with AI. It's when I put the opponent in a bad light with AI. That's when people think it's unfair, and that's what's going to drive the situation, which I think kind of more solidifies my point from earlier about it's really a question of whether it's false. I think that's important. The other one is I would like to, and Mr. Brandt or Commissioner Brandt brought this up in regards to the backgrounds don't matter. I won a campaign in Imperial County because of the background. And in this case, our opponent made very much a pro-choice speech in Imperial County, which you'd say, well, that's exactly what he said, and he did say it. The problem was he did it on basically right in front of the altar of a Catholic church. And it wasn't that what he said, it was where he said it that was the problem in Imperial County. And so the background does matter. It was exactly what he said. But if I could use AI to take those exact same statements and put him on basically in front of the altar of a Catholic church, it changed the delivery and the impact of the ad. So backgrounds do matter because where you say certain things actually matters in terms of the impact on people. So I did want to throw that out. It was an incredibly important thing. And then Commissioner Brandt also brought up what is a reasonable person. And we didn't necessarily talk about that, but his household sounds like my household, which in his case, it's his wife. In my case, it's my children who are 19 and 22. They mock my wife and I because we cannot ascertain the difference between what is AI and what is real. And my guess is, and they do it very ferociously, but the important point is that the reasonable person in this case is going through a whole spectrum. And I believe there's other data, and I wish I would have brought it now, but I believe that there is a huge difference in the perception of what is false or obviously AI created based on the age of the people looking at it. And I think that's true in society right now, where my children can pick it out right away. And for me, it looks like the rabbit's jumping up and down on the trampoline, and it just looks real to me. So I say, yep, that's happened. They're like, that's absolutely ridiculous. Rabbits don't jump up and down on trampolines. But the reasonable person in this case, I think, actually is important because there's a huge difference between people who are older, who are more likely to accept that information, and those people who look at things more skeptically as a result of that. And I do think that makes a difference in terms of the statute that was written and your enforcement of it.
I think those are good points. I want to share my opinion on the first point you made in terms of us being a complaint-driven agency and more likelihood of complaints for essentially attack ads than positive ads. I see it from a different perspective. I think ultimately the regulated community is going to identify the fact that if you have a broad disclaimer requirement for the use of AI, that almost all ads are going to use AI to a certain extent. and then they're just gonna proactively file complaints with our agency alleging the use of AI. And then what they're gonna be able to do, as someone who's been an FPPC prosecutor, but on the other side, I can tell you that campaigns use complaints, the fact that complaints are being reviewed, that investigations are being opened as methods of campaigning, right? To frame the campaign, the race. So you file this complaint, you say, hey, Adam Silver, whomever, John Smith, they adjusted their teeth to look whiter, or they made their whatever, right? They made that specific change. Then we're in the position of making that technological evaluation. And while we're making that technological evaluation, the opponent of that individual is going to the local newspaper and saying, the state's ethics commission is reviewing the ads put out by this specific candidate for not including a disclaimer using AI. So I think that's a possibility too. And that, again, I feel like goes against the intent, the legislative intent here.
Well, but I can do that all day long in terms of producing those things, because I can make all kinds of accusations against the opponent's campaign for disclaimers being wrong, or I can go through all of that. But in terms of the great example given by the speaker who was on the telephone, I don't remember their name, but the age thing's actually real. And if you, particularly with some candidates, you can say, that's an old picture. They used AI to do that. And then suddenly it's in the news discussing that candidate's age, which candidates sometimes don't want their age in the news right now, because I think in 2024 and now in 2026, due to national politics, I think age is more of an issue than it has been in the past 20 years, at least from my perspective.
Right. Yeah. Well, that makes a lot of sense. Ms. Lair?
Sure, and I do apologize. I'm gonna have to step away shortly after this. I had the 2-hour parking zone. I'm so sorry. But I do agree that if there is something that can be shared this year, it will be helpful, not only for the practitioner community, but for the public as well. Because we're in a period of time where the public is rapidly evolving their opinion on AI, concern about AI's impact on elections is a very hot topic. Any additional guidance and normalization of values will probably be helpful, because whether or not additional guidance is issued, complaints will be filed, campaigns will be run. So if we can participate and learn from that participation, I do think it would have a net positive effect. To the extent that alignment across states is helpful, the clarification depicts an individual saying or doing something the individual did not say or do is also being used in Michigan, Oregon, and several other states as sort of the qualifier. So to the extent that that consistency is helpful, that could probably be a net constructive clarification. And then to share after this, I want to offer the study from the American Association of Political Consultants on the recent research that we did on the effect of disclaimers and the effects that it had, and acknowledge that there is a difference amongst different levels of technological familiarity of the effect that that disclaimer has. So there is a disparate impact of the disclaimer across the voting population. They can correspond with technological sophistication, age, and other demographic factors. What we try to really land on with the AAPC and the meaningful disclosure framework is not just the disclosure whether or not AI was used, but how. So like you said, when we see a TV show start, it says, smoking, violence. The clarification of why a show is rated PG-13 is actually very helpful for the parent guiding their child, whether or not they can watch a show. The clarification of how AI is used in the production of a piece of content can actually be very instructive for the public on how to interpret that content, especially when it comes to representation of false events, which is, I think, the thing that we're all trying to prevent against. So I'll share the origins of the meaningful disclosure framework, where we actually created a little bit of a rubric that has a differentiation based on how misinformed or misled someone could be, as a potential offering for a rubric of enforcement to the extent that that would be helpful. And the big question that our bipartisan committee landed on after a lot of discussion and debate was one question, which is, to what extent is this AI-generated content doing the work of evidence? And that was our differentiator. So the extent to which it is doing the work of evidence is the extent to which the public being misled is a factor that could be consideration for an enforcement rubric. So I hope some of those things are helpful. And I'm also just so grateful for everyone who's engaging in this difficult and new set of questions that no one's had to ask before. So I appreciate the care and thoughtfulness. And I apologize, I have to leave early.
Thank you so much for joining us and for your feedback today. We so appreciate you coming, especially in person.
Thanks. It's
And
nice
we're
to be
counting on you continuing to engage with us on as we develop this.
Only if she doesn't get a parking ticket. I assume she's not going to want
And
it.
I better jam. I know they're pretty good.
Yeah, and we're not
about
paying for
timing.
parking tickets.
Thanks, Al.
Thank you.
Okay, so what are we doing?
Sure. Well, I wanted to make a couple different points, and then I felt like it would be appropriate to provide direction to the legal division.
Yep.
Yeah.
Okay.
So one other point in terms of the standards is something I brought up at the May meeting. I felt like we wanted to have in terms of the scope of the types of political advertisements that are going to trigger the disclaimer. I think you want to have a scope that's similar for both entirely created and materially altered. And the reason for that is I don't see any meaningful distinction in terms of harm between the two. And from looking at the legislative history, I didn't see anything that indicated that we feel that AI, or I should say, content that's entirely generated with AI is far more harmful to the public than content that is materially altered using AI. So I feel like creating an arbitrary distinction in how we treat those for purposes of triggering the disclaimer is going to undermine the purpose of the rule here and could lead to creative approaches, let's say, by those who are regulated by the FPPC. So for example, if we have a stricter, broader requirement for including the disclaimer for entirely generated using AI versus materially altered, I would attempt to have my materials meet that second standard, right? The materially altered standard rather than the entirely generated using AI, so that potentially I didn't have to include the disclaimer in good faith because of the issues that Ms. Lair brought up, right? So I am all for having two distinct tests that apply different criteria, if that's what the legislature intended, right? To have different scope for different types of media, but that's not how I view it. I wouldn't think that, for example, the legislature would have intended for a digital ad, right, that was created via text prompt, like we were talking about, right, for entirely generated. A digital ad, the text prompt said, create a digital ad that says Joe Smith for assembly and include in the background a picture of the California State Capitol, right? I don't think the intent was to have that trigger a disclaimer because that's an authentic representation of the state capitol. But if someone created a background for a digital ad using AI, right, or what have you, and then they used clip art of the Capitol in that ad to include the state capitol in the background, creating that kind of alteration rather than that entirely generated, that we would then not expect to have a disclaimer. So that distinction doesn't make sense to me, that why we would include the disclaimer in the first circumstance, but not in the second, just because the first circumstance it was created entirely by text, by direction to an AI model. I don't know if that makes sense. I'm a little confused. But
So tell me, what does that look like if we're using the same scope? What is that? What does that sound like?
Well, like we've all acknowledged, this is incredibly complex. And we just identified the fact that perhaps we want to look closer at an approach that considers deception in both prongs, right?
Right.
You highlighted the use of falsely, which we haven't really focused on. So I'm hoping that after this meeting, we can kind of flush that out, whether that's through an approach where we use a single standard or a single standard supplemented by presumptions, right? But that's ultimately where I want to get at. I don't want to try to speculate or shoot from the hip as to what's the best way to effectuate that. My direction is that I believe that there should be some requirement of some level of deception, right, in both prongs. I don't think it's appropriate to ask for some level of deception for triggering the disclaimer, right? We're showing something that did not happen, right? When you're talking about materially altered. and that is not applied in the first instance. I don't think that's appropriate. I don't think that's consistent with the legislative intent. So that's where I'm hoping we'll go. How we're going to get there, I think it's going to be difficult, but I think we just need to identify what the best approach is based on feedback and the experts in the legal division.
So what I'm hearing is the same standard, not, because I think the statute has two different scopes. I mean, in other words, and I think, so tell me if this is actually consistent, maybe this is that for both of these, we're looking at the entire piece. We're not looking at parts of it. We're looking at the entire piece. So making the judgment about whether it's, whether it is entirely created, it's looking at the whole thing. So that may be, that may not be used in the end very much, because if you're looking at the whole thing, they may create this problem, that the problem that, you know, that it's the recording or whatever. But generally, they've got a photo of her that they took from, you know, the newspaper or whatever. So that one may not be used in the end. But I think I do agree that we need the same standard on either one. So in other words, to avoid them, if I'm hearing you correctly, avoid creators, campaign folks saying, "Oh, well, I'll just do this one," and therefore it's substantially, it's just materially altered, but it's not entirely created. So therefore, I'm sorry, I'm just thinking through. Sometimes I think through talking.
Yeah, I guess a better example than what I said would be, let's just talk purely about the clip art example of the Capitol, right? Is there some substantive difference between me putting into Microsoft Copilot, create a picture of the California State Capitol and hitting enter and getting that picture versus me getting a picture of the California State Capitol from clip art and then putting that in the ChatGPT and saying, hey, will you make this double the size so it'll fit my mailer? Because in the second circumstance, it would be an alteration, not entirely created with AI, right? In the first circumstance, it's entirely created. So I don't see a substantive difference in terms of harm.
But see, I would say then it's about what's the whole thing. So using clip art, if you're using part of it, in other words, you're looking at the whole thing. So I think that it's mostly going to be the secondly materially altered. And because, I mean, tell me, or are there, I mean, maybe that's true, but wouldn't you avoid having it substantially? If you're looking at the whole thing, then it's easy to say, oh, well, I'll create this whole thing and I'll just do this one little recording, or I'll do this one, do this photo of the person in front of a Catholic church, you know, that kind of thing. And so your actual recording, so wouldn't you just avoid ever being, I mean, you can just avoid everything entirely created. Isn't that possible? So isn't all our work going to be on the second one, on materially altered? If we use the entire program, ad or whatever that may be. If we use that standard.
I'll let whomever is interested in responding answer this, but I don't think we have that information yet, right? And I think what we do know is we have this statement from Assembly Judiciary Committee saying, under both categories, the disclosure requirement would only apply if the use of AI results in deceptive material.
Right.
So I'm hoping that is reflected moving forward in the future iterations of this regulation that we present ultimately to the Commission for adoption and is applied to the examples and hypotheticals presented to us by the regulated community. And I'm also interested in not just this issue, but again, the issues that we talked about related to what is entirely created using AI, what is materially altered using AI. Also, we didn't even talk about the record keeping change, the changes to 18401. So I think that would be helpful to get feedback from the regulated community. So there's a lot of different items that I think are kind of up in the air right now. But I think as far as where we are right now in this meeting, I think it's important that we provide legal division with direction as to what we're expecting in August. But with that, that's where I'm at.
Okay,
Commissioner Brandt. you're-
so, but I think we're having differences that aren't differences. So in other words, I'm hearing you say scope, and the scope is, it's the whole thing, and I think that's consistent. And I think you're more focused on that the rule is the same. It's about deception.
Right.
And the rule is the same. But you started with a scope,
Right.
and we're not talking about in other words, it's not the scope issue. It's
Right.
it's the rule issue. It's the terms of it. So I think we're actually in the same place.
Okay.
I think, but are you okay with that? It's in both cases, it's about the whole thing, not about a piece of it. So in other words, entirely created, it may not happen very much because you're entirely created the whole ad, the whole, photo, all of that is entirely created. That's not going to happen very much, I think, basically what I'm hearing now.
Sure. So that's the approach that's been presented to us by the legal division.
Right.
Before, as with all of these different items that we have, I think it's important to kind of understand whether there's potential loopholes. So what if, cited or common cause comes back to us next month and indicates that taking that approach is going to allow for issues in terms of disclosure to the public?
Then I'm fine with that. But I'm fine with considering that at that point. But I think starting out, we start out with it is, and perhaps it is, it's looking at the whole thing, and there may not be, and it may create a huge loophole for, we're not going to have very many entirely created visual or audio media.
Okay. I mean, that makes sense to me. I think that's a valid conclusion based on the information that we have. Is there any feedback from our witnesses on that point, on the application of the requirement when you're addressing whether something's entirely created with AI or materially altered using AI, whether you're looking at the final product as a whole, or you're looking at the content that appears within the product. So I guess what you're saying, Commissioner Brandt, is, I don't want to mischaracterize what you're saying, but if we could stick to the Capitol Dome example. So if I am designing a digital ad and I'm going to use ChatGPT and I'm going to say, create a digital ad for me that says John Smith for Assembly and has a picture of the Capitol Dome in the background, that's entirely created with AI. Okay. And then if, in contrast, if I created with Photoshop without using AI, I know basically everything in Photoshop, there's a lot of aspects of it that use AI, but let's just stipulate that, sorry, that wasn't directed to you, Mr. Rexroad, right? But let's stipulate that using Photoshop in this example is not considered AI for purposes of our analysis here. Okay, so you create this background with the name Joe Smith for Assembly, and then you insert a AI generated photo of the Capitol into that ad. Do we treat that as entirely generated, or do we treat that as materially altered using AI? Up to this point, the way that we've approached it, and please correct me if I'm wrong, General Counsel Bainbridge, is that would be materially altered using AI because we're looking at the whole mailer. Any feedback first, General Counsel Bainbridge? Is that a correct depiction of legal division's opinion on that application?
That's what we would be proposing in our next version in defining entirely.
Okay.
I was just nodding. I agree. Yeah.
And you think that's okay?
Mhm.
Okay. Yeah, so there may not be many there may not be many entirely created because you may do a mix of things.
And I would think, so we talked about how, you could avoid that sort of situation by taking this specific approach. So I think sophisticated parties, yes, you'll likely avoid that. But there's going to be a lot of, like Mr. Rexroad pointed out, there's going to be a lot of unsophisticated parties who are using this. Right. Yeah. So, okay.
Okay, so then entirely created, there will be folks doing that. Yep, okay. Okay, so I'm good with that. I'm good with that approach on it. And then but I agree with the same standard of enforcement. In other words, that there needs to be some kind of deception or something that, I mean, in other words, looking at between these two, even with even if materially altered, fundamentally different understanding, I think we need to bring in deception. I think that's the standard under either case.
Okay. And I think the legal division has done a good job with that in the proposed regulation for the materially altered prong by indicating situations where perhaps something was said, it wasn't said, or something was done that was not done, or a realistic depiction. So one thing I'd note, if we end up going with that standard, I think it'd be helpful to throw in the word public. We pull up so in 18450.12, so subdivision C, media materially altered by artificial intelligence would cause a reasonable person to have a fundamentally different understanding of the altered media when it realistically depicts an individual saying or doing something the individual did not say or do, or contains a realistic depiction of something that did not occur. So putting my enforcement hat on, I think you're gonna have a lot of situations where someone's gonna allege that this didn't occur. The other party's gonna say, well, it did occur. You know, it said this at this meeting, or this happened there, right? So I think it would be helpful for us to say, doing something the individual did not say or do in public. Same thing, contains a realistic depiction of something that did not occur in public. I think there's other ways we might be able to construe that, qualify that, maybe something related to something on the record. I don't know. I'm interested in what legal division proposes there, but I think that this would be very helpful to enforcement as well as the legal division and the regulated community in being clear as to what we're looking at here if we throw in that sort of qualification there. As far as subdivision B, I think we're both on the same page, Commissioner Brandt. We believe that the inclusion of falsely when considering the legislative history along with it indicates that there's some requirement of deception in order to trigger the disclaimer requirement. So I would support language that reflects that as to entirely created. So in subdivision B, I think we can combine that with the definition of authentic. I'll leave that up to the discretion of the legal division as to how they think's the best way to handle that piece. For subdivision A, like you laid out, I would recommend removing subdivision A. I think it's clear from the statute that text that's generated or modified with AI isn't going to trigger the disclaimer. I think making references to AI tools that relate to text can cause confusion for the regulated community. So I think either we explicitly say it doesn't apply to text, which I think can cause some issues, or we just remove this and leave it up to people to read the statute and see the text is not there.
Well, do you mind if I jump in there, Mr. Chair? The statute talks about a cosmetic adjustment, color edit, cropped image, or resized image. I would not think that covers text. That's more photos and other images or maybe some video. So I don't know that that does include text, which is a good segue into an overall comment that we would love clarification on. What is this, subdivision D to B?
Mm-hmm.
Before Mr. Bainbridge mentioned that subdivision A of the regulation was going to be deleted, my comment was going to be that why not take a similar standard and apply it to subdivision D to B of the statute of what is not generated or substantially altered using AI. And to segue off of what you said, I don't know that that description covers text, and maybe it was meant to, but it doesn't really reference text. And so I think a subdivision in the regulation about what is not generated or substantially altered using AI would be really helpful.
Okay, I think that makes sense. And the aspect of the statute that I was looking at in terms of determining that it didn't apply to text was the definition of qualified political advertisement. When it says means an advertisement that contains any image, audio, or video. So I felt like that made it clear. But we ultimately, our goal here, one of the goals is clarity. So I think that's an important piece to touch on. So we have those three.
Then D2,
Okay, great.
and then D2 also references other media beyond that though, so that cover checks are not, anyway.
No, that's a good point. Mr. Wang?
Yes, hi, sorry. So back, just to take us back just for a second on the kind of entirely generated, I'm wondering kind of if the Biden robocalls that were subject to controversy a couple of years ago, whether that would constitute kind of in A. And then I would also say that for text in particular, kind of back to my reference to the California AI Transparency Act, text does not currently contain kind of provenance information or will not contain provenance information. So that's a separate category.
Yeah, agreed. Text is a particularly tricky medium to regulate in terms of AI, as any, I'm sure, high school English teacher or history teacher can tell you. Okay.
But it would apply to the Biden robocalls.
Would
I mean,
it?
entirely created.
So I'll direct that hypothetical to our general counsel, and I think the hypothetical is if someone created a robocall using the voice of a politician and then asserted that this was the voice of this was a call from that specific politician, and was it entirely generated? Is that what the question is?
Right.
I don't think it's, first of all, I don't think based on how we're looking at entirely generated, how Mr. Bainbridge could even tell us really, because we're deciding to define entirely generated as something that is created via a text prompt, right? And we don't know if that robocall with President Biden's voice was created with a text prompt, or if it was created by uploading a bunch of different WAV files or whatever. That's probably really aging me. I don't know what files you use now for audio, right? Which we would treat differently. And that just goes to why I think it's so critical that we have a similar analysis, a similar test for when the disclaimer is triggered for both entirely generated and materially altered. But I'll throw it over to General Counsel Bainbridge.
If it were entirely created, it would not be authentic. So it would falsely appear to be authentic. So I think it would require a disclosure.
Yeah, and I think we can to give guidance to Cited and whomever. I think we would both agree that we're hoping we can get to a regulation that ultimately would make that sort of communication where you're mimicking the voice of a sitting politician in order to influence voter activity, right? That is the sort of thing that was the intent of the legislature for this to apply to. Anything additional,
No.
Commissioner Brandt?
No.
General Counsel Bainbridge, do you feel that you have the feedback from the policy committee that's necessary to move forward?
Yep.
Great. Is there anything additional our witnesses would like to add? Okay, well, thank you so much for being so generous with your time. I know we're in the middle of a campaign year, and this has been probably one of the longer Law and Policy Committee meetings that I've been a part of. So thank you again. Thank you, Mr. Wang. Really appreciate you joining us, and I hope you feel better. Okay, great.
Okay.
Thank you. We're
Thank
gonna,
you all. We
before
really
we do
appreciate
that, just so we're following the rules here, do we have any public comment online or in the room? No, we do not. Okay, excellent. We're not taking
I
any
couldn't
action
unmute
on this
myself,
item?
but thank you.
Thank you.
Okay.
Okay, so thank you again for coming. Excellent. And we're gonna move on to our last item. Here we go. Our last item is item number 4, and that's going to be discussion of items for the next Law and Policy Committee meeting, to the extent that there are any. I don't have any suggested items. I know or you would know much better than me, Commissioner Brandt, we're coming up to a lot of different legislative deadlines. So to the extent that you're interested in having a meeting to discuss legislative updates outside of the August meeting, which I don't necessarily think is necessary here, but I want to open it up to see what your feelings are.
I do not think that at this time of year that it's helpful to have a committee meeting, because I think we need to move more quickly. So great you came. We would need to move more quickly at this time of year. So that's why it needs to have having a committee meeting to dig deep. I think the time, if anything, the time for the next Law and Policy committee meeting is probably sometime in the fall. Later in the fall when we start to see what so November, December, to see what they've done ultimately, and then what is looking to develop. And because we have some of the things that we've talked about as needing further discussion, including the item we talked about today. So I think that's the next my sense of the need for the next Law and Policy meeting is late fall about legislation.
Okay, great. I think that's a great idea. I also
We have
want
the
to
star of the show here.
throw a shout out to our only remaining audience member, which is our senior legislative counsel, Ms. Nakano.
Thank you for joining us.
Congratulations, Ms. Nakano, in getting our first 3 bills through, signed by the governor. We're looking forward to the rest of them, and great job so far this session. So now I'm going to move to adjourn. Do I have a second?
Second.
Okay. Ms. Vo?
Commissioner Brandt,
Aye.
Chair Silver,
Aye.
meeting adjourned.